rise. Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV140055, Shano versus Shano. Counsel, we are recording today's proceedings, so as you step to the podium, please identify yourself and the client that you represent. Each side will have 20 minutes for argument, and appellant's counsel is responsible for reserving any time for rebuttal that you may desire. We have read the briefs, and we've conferenced the case prior to argument. So at this time, counsel for the appellant, you may proceed.
Thank you, Your Honor. May it please the court, my name is Stanley David Murray, and I'm the attorney for the petitioner appellant, Deborah Shano. I would like to reserve 5 minutes of my time for rebuttal. Generally, when we calculate child support income for child support purposes, we can look at tax returns, pay stubs, and W-2 statements and come up with a pretty accurate and simplified calculation for income. But things get a little more difficult when you're dealing with people that own businesses who take draws, salaries, and also have distributions and K-1s, and especially if they own more than one corporation. There's a lot of different mathematical calculations that come into play. So we rely on experts to do that for us, and that's what ARS 25-320.02 is all about. It allows the court to appoint an expert, a federally authorized tax practitioner, to do the math for us, so to speak. And it's convenient because the parties can share the costs of just that one expert subject to later reallocation, but at least we have an expert analysis of the incomes of the parties. The problem here with the expert that was appointed is that he failed miserably in his job, and as it turns out, he wasn't qualified as a federally authorized tax practitioner.
As to that last statement that you made, where was that raised in the Superior Court in a timely fashion?
It was raised in the motion for new trial, Your Honor.
Yeah, and as you probably know, a motion for new trial doesn't preserve arguments for appellate review when they're made for the first time.
Unless the parties reasonably relied on representations made as to that person's qualifications. And I've cited several cases in my reply brief pointing out that the parties reasonably relied on the representations that Mr. Adelson was a CPA. And so there's no reason for any questioning about his qualifications, as it had been represented to the court he was a CPA. And also Mr. Adelson testified that he was a CPA. But he never testified he was a federally authorized tax practitioner. And as it turned out later, we found out that he wasn't a CPA, that he wasn't registered in Arizona, and that his license in Ohio required him to have a permit. So once we presented that newly discovered evidence, if you will, to the trial court should have acted on that and said—
How is that newly discovered? Wasn't that all available before he testified? I mean, I understand his report came in right before the hearing, but his appointment came months before, so that was easily ascertainable. I know you weren't trial counsel.
Well, yes, but I can put myself in the position of trial counsel. If somebody tells me that this person's a CPA and they're representing to the court that these persons that I'm submitting are sort of federally authorized tax practitioners because they're CPAs, I'm not going to question that, and I can't blame trial counsel for not doing that.
That person gives. And again, you weren't trial counsel, so I'm not faulting you, but
Right.
None of this came up until the opinion Mr. Adelson gave was displeasing to your
Until
client.
we've got the final ruling from Judge Hicks where she adopted Mr. Adelson's report in toto. And at that point—
Help me out. You're saying that you relied on the fact that he was a CPA. He was a CPA, correct?
not a licensed CPA, and apparently that's required in Arizona for him to provide testimony.
Well, but I thought, isn't the sort of requirement by statute that he was a federal tax practitioner, fair?
Federally authorized tax practitioner.
Okay, and that, I'm guessing, is somewhat different or maybe a subset of CPAs, correct?
Right, you don't have to be a CPA to be a federally authorized tax practitioner, I understand.
So Judge Downey had asked about the motion for new trial, and you said, wait a minute, we were relying on the fact that he was a CPA, which is different than whether he was a federal tax practitioner.
That's true.
Okay, so how was this raised in a timely fashion?
Because it was at that point when the report was adopted by Judge Hicks that trial counsel took a look at this man's qualifications to determine if he was either an FATP or a CPA. And as it turned out, course, he never testified at trial that he was an FATP, federally authorized tax practitioner. So there's no foundation on that point. And then she finds out later that he's not even a CPA in Arizona.
Well, but the challenge isn't that under the statute, and I'll use, because I think I've been missing a word, I'll use your initials, FATP, as a shorthand, but the challenge is that that's what the statute requires, and he wasn't that. Fair?
Correct.
He never represented, though, that he was that. Is that fair?
Well, he says he's been doing this for 30 years.
Well, he's been a CPA for 30 years, he says.
Right, but handling tax matters is the implication that I got from reading the transcript, and I would imagine that would be the same impression on trial counsel. If this guy's a CPA, he's got to know the tax records, he's got to know the tax requirements.
And I understand that, but I thought your challenge was that he failed to comply with a specific statutory obligation for an FATP, not for a CPA, for an FATP.
Right, that there was no foundation to establish he was an FATP.
How did that not come up at trial, either come up at trial or be waived by having it not come up at trial? In other words, how come, you know, your argument is you didn't need to waive this until, or raise this, pardon me, until after trial, and in fact, after you get the ruling, and then you can raise it in a timely fashion?
Right, because counsel submitted to the court the list of 3 persons they represented were authorized as FATPs, because that's what the court asked for. So there was no reason for anybody to make any inquiries at that point.
What then changed after the ruling,
Further
as opposed to
investigation.
at trial?
Right, I guess I'd have to answer that with further investigation.
Okay.
Because the way that report was written, trial counsel had some suspicions about Mr. Adelson's qualifications.
And that was provided very shortly before trial, I understand that, but.
Yes, about 4 days before trial.
But those suspicions weren't acted on prior to trial, at least that we know of.
Right.
And that issue wasn't raised at trial, even though apparently there were suspicions prior to trial.
Well, actually, my trial counsel never got to cross-examine Mr. Adelson because you will recall that Judge Hicks cut everybody off in the middle of the direct examination by Mr. Cook.
But nowhere did your predecessor, to be sure, as Judge Downey has pointed out, say, Judge, by the way, we have a concern about qualification.
That's correct, Your Honor. And I think the motion for new trial was the appropriate method for bringing that to the court's attention. But aside from the qualification issue, we also have to look at Rule 702 of the Arizona Rules of Evidence. I'm not going to read it to you what all the requirements are, but we believe that Mr. Adelson did not meet the qualifications by providing testimony that was based on sufficient facts or data, that he used reliable principles and methods, and that he reliably applied those methods. And that's the Dover test that's been codified into Rule 702 by the Arizona Supreme Court, effective in 2012, I believe. So even assuming that Mr. Adelson was qualified and had the scientific knowledge, the testimony in his report were not based on sufficient facts. There's nothing in that report that tells you how he came up with $11,667 for Mr. Chano's income.
Well, but he testified about that. He took the W-2 income, he divided it, he added $2,500 per month. I mean, it seems to me you're challenging the weight that should have been given to his testimony and asking us to reweigh it. And on the flip side, when it came to your client, to some extent, both he and the court threw up their hands because the records had been destroyed and said, this is the best that we can do under the circumstances because your client destroyed records both before and after the modification proceedings were filed. So it seems to me you're asking us to look at the evidence and reweigh it and say Mr. Adelson was wrong and some amorphous standard for missing business records should apply to determine her income.
Well, let's back up to when that report was published. That was July 29th. When an attorney sees an expert's report, we look at it to see what the analysis was. We look to it to see if it's reasonable, these numbers that he's coming up with. There was no basis for trial counsel to consider how he came up with those numbers. And yes, later he testified about that. But the first part of my analysis deals with the report itself.
But in a bench trial, it's different. The whole purpose underlying 702, and we've even got 2014 appellate decisions saying the gatekeeper function is to prevent unreliable information from being presented to the jury. We've got completely different tenets when it's a bench trial. Trial judges are presumed to disregard improper, inadmissible evidence, and so Judge Hicks could, in the context of a bench trial, listen to Mr. Adelson, and if she listened to him and thought he doesn't meet the standard, she would just disregard his testimony. So I don't think you can look at the report in a vacuum like it seems you're asking us to do.
Well, I'm looking at it from the perspective of trial counsel preparing for trial. And when she didn't even get a chance to cross-examine him, how could she prepare for any effective cross-examination
But
based on
Judge
this
Hicks offered a
inadequate report?
continuance, and that was not accepted.
True. The continuance wasn't about Mr. Adelson's
was-
qualifications. It was
it
about
was-
time limits, Your Honor.
Absolutely.
Exactly. They only had 3 hours to do this trial, so they were going to do that trial anyway. The question was whether or not she was going to continue it to another date so that cross-examination could occur of the expert or more testimony could be brought in. So that report, that's why I kind of put it in a vacuum, if you will, because it didn't give counsel time to prepare for the trial, to critique the analysis, and that report was admitted as an exhibit. So I'm attacking that report under 702 because it doesn't meet the qualifications or the requirements of Rule 702. Judge Hicks should have kept that out. And even if he did testify about it, she would have found that the methods that he used were not reliable, that they weren't based on accepted principles. And I hate to use a cliche, but the document speaks for itself. This report is terrible. It doesn't meet the requirements of 702. So let's go on to his testimony.
Before you get there on the report, don't we owe a fair amount of deference to the trial court in making that call?
Yes, sir, and it's kind of a confusing standard of review, but I have to admit that there's the recent Supreme Court case. I cited the State versus Salazar, the Court of Appeals opinion, because at that time when we wrote the briefs, that was the opinion that existed. But you'll see in the Supreme Court review of State versus Salazar, they vacated the Court of Appeals opinion, and they stated that the admission of expert testimony is reviewed for abuse of discretion. But there's also a section of this analysis where you have to review de novo the rules, the application of the rules. So
Wasn't
you
that,
review,
though, in Salazar, in the Supreme Court's opinion, the opinion found there was an ambiguity as to whether D applied when you had a cold
testimony.
Right, which is factually very distinguishable here. But in determining what the specific rule means, that's right. It's like a statute. It's de novo review. But in application of the rule to the facts, that's an absent confrontation clause issue, which we don't have here.
Right.
This court owes great deference to the trial court.
And that's true, and that's why I'm going to attack this as an abuse of discretion issue. Because when you look at the testimony and the report of Mr. Adelson, where he takes 20% of the gross income of First Kiss to determine mother's income, that is not based on accepted, reliable principles of accounting. And in fact, he didn't even cite to the IRS guideline that he says allows him to do this. So Judge Hicks should have been extremely suspicious of that testimony without the backup that most of these reports contain, or at least his testimony should have contained. And by the way, there's math errors all over the place when you look at that analysis. He testified that he took the gross income from 2012 for First Kiss. First problem, Mrs. Shano does not own First Kiss. She gave that to her husband in 2009. It's a sole and separate property. She doesn't receive any income off of that company. So if it belongs to the husband as a sole and separate property, why is any income being attributed to her? Second problem, he says gross income. If you look at that 2012 income tax return, the gross income for First Kiss was $102,000, not $280,000. That's gross sales. And Mr. Adelson did not use the term gross sales. He used the term gross income. So if you apply 20% to $104,000, even if that is acceptable, you don't come up with $5,000 a month.
And where was that argument made in the trial court? The one you just made to us?
Again, we were cut off.
What was it?
Trial counsel didn't get a chance to cross-examine it. But again, my analysis is based on the abuse of discretion in letting that testimony in when Judge Hicks didn't consider the requirements of 702, reliable methods. And then it's a math error also. If you take the $280,000 times 20% to divide it among the owners, if you consider Mrs. Shano to be a 50% owner, it comes out to $2,333, not $5,000 per month. So math errors. Mr. Adelson said that he had to do this methodology because there weren't any source documents. And I don't know what source documents were missing, because you recall Judge Hicks appointed Mr. Adelson to determine these discovery disputes, and that Mr. Adelson was to determine what documents he needed, what documents were relevant. We never heard from him. We submitted all the documents he asked for. Actually, Mrs. Shano did it through her husband, Jay, who was the owner of First Kiss. Mr. Adelson never told Jay or Mrs. Shano that, hey, we got problems here, I need more information. Never complained about the response times of the documents that were produced. But all of a sudden, he's looking for source documents. And he testifies, I'm not doing an audit. It's going to take 150 hours for me to do an audit. Well, yeah, we didn't expect him to do an audit. We expected him to review the documents, determine if the incomes were appropriately reported, determine if there was perks and cash in-kind benefits that should be attributed to income, and whether there are other distributions from other corporations. We look at the father's side of the equation. He has 4 or 5 different companies that are making plenty of gross sales. Why didn't he apply to 20% to those corporations? All he took was the salary that he got from the ICA company and divided it by 12, and again, he used the wrong number there. It was supposed to be $122,000 that was paid to the husband in salary, to Mr. Shano in salary. So the math was wrong in that respect, and it was wrong in the methodology that was used because there was other income that he received. I'm down to 4 minutes, so if the court has any other questions, I think I better save my time for rebuttal.
Thank you,
Thank
Mr.
you.
Murray. Mr. Cook.
Thank you, Your Honor. May it please the court, my name is Alan Cook. I represent David Shano, the appellee in this case. If I can summarize this case, Your Honor, there's never a time when a lawyer looks back at a case a week later or 2 weeks later and say, I wish I'd done something, hadn't done something different. Everybody always wishes they'd done something a little better, a little differently. Could I have asked Mr. Adelson for a CV to see if he was actually admitted to CPA in Arizona as opposed to Ohio? I could have done that. Didn't think to. He'd been a witness in a previous case. Nobody was unhappy. I didn't. So that's my experience with him in total. What this case is all about is, as I see it, maybe 3 or 4 things. Number one, for reasons we've cited you under the law, we have 3 people testifying at trial, and the court isn't required to believe any of them. The court isn't required to believe even the uncontradicted testimony of an interested party. So that means it doesn't have to believe father, doesn't have to believe mother. Also has discretion to believe or not believe Mr. Adelson. Mr. Adelson was working on this case for about 10 months. And in no time in that 10 months did mother ever make any inquiry about his skills or training or expertise. To be a federally authorized tax practitioner, any CPA is considered a federally authorized tax practitioner, as is any lawyer. You don't have to be a CPA in Arizona to be a federally authorized tax practitioner, and Mr. Adelson actually did testify that that's what he does for a living. He's been doing it for 30 years. So, do I think he could have written a better report? Sure I do. I think everybody can write a better report. And, you know, I think the world of Mr. Murray, and I appreciate the difficult position he's in here, but the fact of the matter is there's evidence in the record, and we've cited you to it, that the reason no one can make an adequate calculation of mother's income is because they throw away their original records of income. She said they have a 2-part form, and when the person makes an order, they give them half the form, and when they fill the order, they give them the other half, and they don't keep any records, and they do a substantial cash business. So when they say nobody told them what they needed or whatever, it's because mother said they don't keep it. Mr. Adelson was present for mother's deposition, father's deposition, and mother's husband's deposition. And mother's husband's a CFO of a company. He's a chief financial officer. You would think somebody who's a CFO of a company would know that you're supposed to keep your original records, but they don't. Mother's case here is basically that she gave away her 2 income-producing assets. She said she gave away her business, even though the Corporation Commission records say otherwise, even though their tax returns say otherwise, and her husband's the guy that does them. You would think that her husband, who's responsible for getting that done, you know, whether he has a CPA do it or he does it himself, you'd think that he would know if he's a half owner or full owner of a business. So, you know, I don't see where that washes. This is a case where mother made it impossible for anybody to determine what her income actually was. She also gave her husband a half interest in rental property that pays $2,000 a month in rent. So do I think that Mr. Adelson's wrong? I do, but for a different reason. I think mother's income is a lot more than that. But father, unlike mother, was willing to walk and let things be, even as expensive as this case was. But I would submit, Your Honor, this. You can add $3,000 to father's income and rerun a child support calculation. It's not going to be materially different from the one you have. That's how it is with these things. If they can be off a little bit, and it doesn't matter. But part of the problem here is that mother cherry picks what she wants the court to think father's income is. So she looks at financial statements or whatever submitted to banks. And father's explained in his testimony why the income figures on those applications is incorrect. And so the court's free to believe him about that those things were done at the suggestion of the banker and they were subsequently amended. That's what he said. But he also gave the court Exhibit 140. I didn't mention that in the answering brief, but it is attached to our appendix. And his Federal 1040 for 2012 shows that he and his wife jointly had adjusted gross income of less than $18,000 for the year. And I would submit to you, Your Honor, that when you have a man who's an entrepreneur, and if you read the record, that's clearly what husband is. He starts and builds businesses and whatnot. I don't think you just get to pick the income and ignore the losses that go along with doing that. Entrepreneurs don't just make money, they also lose money. And so when you look at father's circumstances, he and his wife combined made less than $18,000 for the entire year of 2012. But he manned up. He said, sure, my salary's $110,000 a year. He gets about $2,500 a month in perks from his principal business, which is ICA, Innovative Circuits of Arizona, in which he is only a half owner, in which the bank makes checks of their financial records and has restrictions on what they can spend, for which he and his partner, he said, had to return some of their salary to the company for financing to maintain liquidity. I think father's income's overstated, but father didn't appeal that. You look at the entire history of the case, Your Honor, it's the money that was spent on this case when you're talking about a difference of $1,200 or $1,300 a month in child support for a couple of years. I mean,
That's
it really,
a nice segue to another issue that Mr.
Yes.
Murray didn't address.
Yes.
But talk to us about the attorney's fees award. I know there's authority for the proposition that the less financially well-off spouse can be required to pay fees, but it's a large fee award. Why is that appropriate?
Well, it's only a fraction of what was incurred, Your Honor, number one. And number two, it's because wife was not forthcoming and she repeatedly made false statements about her income. She first said her income was only $500 for the year. Later on, she admitted to $5,000. Later on, she said she would agree to minimum wage of $1,326 a month. When it was plain from her business that her business was generating tens of thousands of dollars, and even though she said she was disabled, she also said she had no disability and nobody had found her to be disabled for purposes of working. She said she could work. And she did work. She traveled the country to these sales shows and making sure every step of the way that they threw away their original income records. So I think the court's award was based, Your Honor, on what we're asking the court to base the award on here, where father's request is based upon the patent unreasonableness of mother's positions, Your Honor. And
you also argued, and I think Judge Hicks considered the settlement negotiations that had transpired, and
yes.
And I know there was a lot of back and forth, and retroactivity was an issue, attorney's fees was an issue, but is it your position that every monetary award your client offered to settle was higher than the court's ultimate award?
Yes. Every single one. Father started off, I think, at $500. I think he testified at $1,000, but I think it was actually $500 a month, or it might have been $1,000. I don't think it was $1,000. But mother rejected it. And so we ended up doing discovery because mother's position was that he should be attributed something like $30,000 or $35,000 a month in income, and she should be attributed $500 a year. Okay, that's where it started, and it never, frankly, got much better than that. The last time she offered, finally said, well, make it $1,000 a month, was very late in the day after he'd already incurred $40,000 or $50,000 in legal fees, and he was even willing to pay. I think he was even willing to pay that if she was willing to let the court make a judgment about attorney's fees and costs, but she wasn't willing to do that. And she also was not willing to start it effective with the first day of the first month after service, which would have been June 1 of 2012. She wanted it to start in January or February. So she did this all along, Your Honor. It was unbelievably expensive. We had to subpoena records, and I've detailed that in my China doll affidavit, Your Honor, just to make sure the trial court remembered all these things that had happened. And but I give Mr. Murray credit. We've always settled stuff. We've never had to try a case, but I think his argument is wanting with respect to the federally authorized tax practitioner, because Mr. Adelson is clearly that.
And counsel, I was just going to clarify,
Yes.
your position is that he absolutely complied with any statutory obligation.
Yes, in terms of his experience and training in his work, yes. Nothing in the federal tax practitioner provision of the statute requires that they be an Arizona CPA, and any CPA is authorized to practice federal taxes, as would be any lawyer. But you don't even have to be a CPA to be a federally authorized tax practitioner. You don't even have to have a degree in accounting. If all you have to do is pass a test, and you can be a federally authorized tax practitioner. So if you've got the training to do taxes and you pass the test, you can be an FATP. So CPAs, wherever they're certified in this country, and lawyers are presumed to be competent to do taxes with the Internal Revenue Service. So you don't have to take the test if you're a lawyer or a CPA, is my understanding, Your Honor. So, I used to be a CPA myself in a former life, and I think once an accountant, always an accountant, but not necessarily a CPA unless you're presently certified. And I admitted to the mea culpa. I thought that Mr. Adelson was certified, and I didn't know that he wasn't, but it turns out he was certified. He testified he's certified in Ohio, I think. That's what he said. With respect to their argument regarding the expert witness business, they complained that wife didn't have time to ask any questions of Mr. Adelson in court. Well, mother's lawyer and father's lawyer got equal time, and each decided how they were going to spend that time. And mother chose to try to spend the time by having father testify that his income was $25,000 or $38,000 a year, and he pretty consistently testified that wasn't true, and he told him why, gave explanations. Most of the testimony was by Mr. Shano. And I think the court found him to be credible. He admitted what he did was wrong, but he was very forthcoming. For example, I don't think there was any proof. I don't think anybody could prove how much he actually had in the way of perks, and most people say hardly anything, but he admitted that. He said, yeah, about $2,500 a month in perks. He gets health care insurance at $850 a month for his family, part of which covers the children, and he said some meals and some travel is what he said that he gets. But keep in mind, he's got a partner in his business. So somebody else is looking over the books too. It's not just him. And he also had the bank, their lender, scrutinizing the books too every year. So, you have some disinterested parties who want to make sure that people aren't peeling off a lot of money that they're not reporting for tax purposes. Everybody knows that there are some perks when you have your own business, but certainly I think the court had every reason to think that Mr. Shannon was credible. And to his credit, he didn't come to court asking the court to only attribute $1,500 a month to him in income, because that's what his 2012 tax return showed in terms of the adjusted gross income of him and his wife. And that's attached to our appendices, Your Honor. So you can find that in our appendices. That's Appendix B, and it shows it's not the adjusted gross, the total income on line 22 before you even get to AGI is $17,734, and the adjusted gross income was $842 because you get to deduct self-employed health insurance deductions. That applies to that. So when you look at his actually adjusted gross income, $842 for the year. And that's what he testified to, Your Honor, that the businesses are doing bad. So everybody knows we had an economic downturn, and some businesses go up and down, and he testified his is a tech business. So everybody knew that. And that was part of the problem. And he even testified if his income had continued at $30,000 a month, or roughly what it had been in 2010, he wouldn't have filed a petition to modify. He filed a petition to modify because he had a downturn in income and business that made it difficult for him to support himself without using savings, which is what he testified to. They were tapping savings to pay their monthly living expenses. So I would submit, Your Honor, I understand it's a difficult case, and I understand you could do an analysis of the statute requiring the appointment of a federally authorized tax practitioner and make a decision about whether or not Rule 702 should apply and whether or not you should have a Daubert hearing with respect to all that. But I would submit that should be a case where the parties submit their financial records and they haven't destroyed their income records. Not a case like this where I think the court clearly found mother's testimony to be not credible at all. And I heard the argument that Mr. Murray made with respect to mother only owning half the business. I've been doing this kind of work for almost 30 years. And I know that if you had a father coming in here asking to modify child support because he gave away his businesses and now his wife earned all his money, even though he continued to work the businesses, I think that would get short shrift, and I don't think it should be any different because it's the mother who did it, because that's what's happened here. You have a mother that started this business, that worked this business, that still continues to work the business, who's listed as the buyer of the business and as a vice president of the business on the Corporation Commission records, and who does most of the hard work with the business, and she says, not me. $500 a year, that's all I make. Well, I would submit to you that's not credible. I think I make reference, but I could stand to be corrected. Their primary product costs them 31 cents, they sell it for $3. That's a 900% markup, and yet they say no profits. And I think Mr. Adelson was reduced to trying to do an estimate, and I think he had a reasonable basis for doing the estimate. I don't think he included all the mother's rental income, and I don't think he included all the income she really has, but nonetheless, at some point in time, the bleeding has to stop, and I would hope that it would stop here with your decision in this case. I'm happy to answer any questions the court has. I would say this one thing. Generally speaking, parties have to submit financial statements and income statements with respect to relative financial resources under ARS 25324. Now, you have before you Mr. Shano's 2012 tax return, his amended return, which is the most recent tax return as of the time of trial, showing that the adjusted gross income for his wife and himself was less than $1,000, but the income before adjustments was a little less than $18,000. That's factoring in the losses with the income. It reports over $140,000 in salaries, but when you take into account the losses, much less. But we're asking the court to make a decision based upon reasonableness that I think is supported by the trial court's own rulings with respect to reasonableness. And we wouldn't be here making this request if there was complete disclosure. And the reason this case is so expensive is because wife refused to do that. Or mother, I should say, refused to make complete disclosure about her income, saying that she destroyed the records. And to me, destroyed means they don't have them anymore. My understanding was they shredded them or did something like that, but she testified at trial as there's only a two-part form, and they give the customer one part when they make an order, and they give them the second part when they fill it. And so there is no copy of what they actually bill people for what they do. So you can't tell, for example, if they sold somebody 40 letters for $120 for which they only paid $12. You can't tell that because we don't have those records. And that was the crux of the problem in this case, that those records did not exist. Even after the case started and we asked for them, they still didn't keep them. They still gave them away. So I'm happy to answer any other questions, Your Honor.
No, thank you.
Thank you.
Rebuttal, Mr. Murray?
Thank you, Your Honor. In regard to the mother's income, mother testified that she had health problems and she quit the business in 2009. Where is the testimony that she's still operating this business after 2009 on a day-to-day basis, that she's running around to all these shows, selling goods, buying goods? She took herself away from the business, and at most she testified she might have helped out a few times, but she wasn't able to travel as she used to. So there's one problem with that analysis. The court, Judge Hicks, ordered attorney's fees because mother refused to cooperate in providing information about her various sources of income. There's no source of income in this record. She quit her job. She wasn't working anymore, so at most, minimum wage should have been attributed to her if the court found she was able to work, and the rental income of $500 per month, we're not arguing about that. So she was correct when she said she only made $500 a month in income because that was from the rental income. Or when she said zero because she wasn't getting wages. Or when she later said she made $5,000 a year based on probably the part-time employment with the First Kiss operation. But she wasn't a full-time operator. She wasn't drawing a salary. And if you look at the tax returns, you can see that this company is not some multi-million-dollar company that's selling jewelry, making gross profits of $3 on each item that only cost them 30 cents. It's just a confusing of the issues that the evidence doesn't support any finding to support mother's increase of income from $5,500 a month to the present day, when back at the original trial in 2000, she was only attributed $2,000 worth of income, part of that based on the spousal maintenance that Mr. Shano was paying. And that's common sense when you look at this case. One child emancipates, and child support gets reduced from $1,529 a month to $245 per month. It doesn't make sense, and it doesn't fit the analysis, especially when father was making $15,000 a year back in 2000, and now he's only making $11,000 a year. It doesn't fit. Mr. Cook talked about the company earning in 2010 a lot of money, 2011 a lot of money, but there was an economic downturn in 2012 that he reported only $17,000 in adjusted gross income. Well, in 2010, he reported adjusted gross income of over $300,000. In 2011, he reported adjusted gross income of over $400,000. And gee, isn't that a coincidence that he files a petition to modify child support in 2012, and now he's only reporting $17,000 in income? That is why the court shouldn't rely just on tax returns, and that's the straight case that says you have to look at more than just tax returns, because obviously that's not the true amount of income or benefit that father enjoyed in 2012. The attorney's fees issue. The discovery issue was never resolved. My client or her attorney had filed an amended motion for protective order because she was alleging discovery abuses by counsel for father. That issue was never resolved. There was no basis for the court to conclude that mother was obstructing or otherwise interfering with discovery.
But wasn't there a motion to compel that husband filed that was granted by the court?
Yes, without an explanation as what was missing. But at that same point in time was when Judge Hicks assigned Mr. Adelson to determine what discovery was necessary. So it's either a moot order or an order that had no effect because Mr. Cook never followed up with any motion for sanctions or any further request for production of documents. It was my client who filed an amended motion for protective order that Judge Hicks never did rule on. So this discovery abuse issue is water under the bridge. The sources of income, the various sources of income, again, my client was not employed, and there was no proof that she was effectively operating this business after the fact that she turned it over to her husband. I have 10 seconds left. Does the court have any questions? Thank you for your time, Your Honors.
Thank you. Thank you both for your arguments. We will take this matter under advisement and issue a ruling in due course. At this time, the court will stand in recess in preparation for our next argument.